is presiding is Nancy. Please be seated. Good morning, everybody, and welcome to the First District Court of Appeals. We have 5 cases today that are going to be argued. When I state your case, please, if the attorneys could please stand up, state your name, who you're representing, and your readiness to proceed. The first case will be State v. Mark Hammonds.
Your Honor, Elizabeth Conklin on behalf of Mark Hammonds, we're ready to proceed.
Good morning, Your Honor. Keith Sauer for the state ready to proceed as well.
Thank you. The next case is State of Ohio versus Darrell Hammonds.
Good morning, Your Honor. Angela Glazer on behalf of Mr. Hammonds. I'm ready to proceed.
Thank you.
Keith Sauer on behalf of the state.
Thank you.
Thank you.
The next case we have is State v. Rhonda Watts.
Good morning, Your Honor. Sarah Nelson on behalf of Ms. Watts, ready to proceed.
Thank you.
Your Honor, Sean Donovan on behalf of the state, ready to proceed.
Thank you. And next we have Trinity Aviation LLC versus Northside Bank and Trust Company.
William Pecker on behalf of the appellants, Gay Cross Village, ready to proceed.
Thank you.
Your Honor, Michael Lasso on behalf of Northside Bank and Trust Company, LLC, Cross Appellate.
Okay, thank you. And then finally, we have Platinum Real Estate Holdings versus Slabakis.
William Pecker on behalf of Mr. Slabakis, ready to proceed.
Good morning, Your Honor. Charles Russ on behalf of Platinum Real Estate Holdings, ready to proceed.
Okay, thank you very much. We will have a short recess before the 5th case, and Judge Kinsley will be sitting for me on that case. We will be using the light system. When you see the yellow light, that means you have about a minute before your time is up, and then the red light means that your time has expired. The first case, please come on up. And if you could let me know before arguments whether you would like to reserve time, I would appreciate it. Whenever you're ready. How much time would you like, Ms. Duncan?
Let's go 10 and 5.
Okay, thank you.
Your Honors, Elizabeth Conklin on behalf of Mark Hammonds, the appellant. May it please the court. We raised numerous assignments of errors in our brief, and for kind of ease of presentation, although the co-defendant, Darrell Hammonds, is separate from mine, we are going to argue separate assignments of error that are similar. So I'm going to be arguing the first assignment of error in my brief, which is the failure to produce the JFS records, and then also the failure to grant the motion severing the defendants from each other. And Ms. Glazer will be arguing failure to sever the counts and the remote testimony issue.
Okay, thank you.
So our first assignment of error is that the trial court abused its discretion in failing to produce the JFS records to Mr. Hammonds. The first argument in support of our position is that the trial court applied the wrong standard of law. In the statement that the trial court made in making its ruling, specifically said, I find nothing exculpatory in these records for Mr. Hammonds, and therefore I'm denying his right to have access to them. According to Kyles v. Whitley, Ritchie, Bagley, that's the wrong standard of law to apply. The correct standard is materiality, whether the information, any of the information contained in those records was material or could have been material to Mr. Hammonds' defense. And clearly, the information provided in those records, which showed that there were prior examples of the children, DD and JD, making false accusations against other people that had been actually investigated by the JFS organization and found unsubstantiated. There was information stating that JD and DD had mental illness diagnoses, specifically schizoaffective.
So how does that come in at trial? Let's say you get those records. How does that come in at trial? Is
The
it
records
solely
that-
impeachment or?
Yes,
Okay.
primarily impeachment. But also, there were entries by the caseworkers saying that over the course of the years that these children were followed by JFS, they would ask them, how are you feeling in your home environment? Do you feel safe? Yes, we feel safe, repeatedly, year after year. Has there been any abuse of any kind, any behavior that makes you feel uncomfortable or unsafe? No, we're fine. The caseworkers also observed the children interacting with both Mark and Daryl Hammonds and concluded that the dynamic among them substantiated their conclusion that this was a good environment for the children, that there was nothing.
But what about like the state's argument that like, okay, right, but there's reasons why there's delayed disclosure often in these kind of situations. Does the fact that there wasn't the accusation more contemporaneous with the alleged assaults, does that not, like how does that play in the overall analysis?
Well, I think during the trial, the argument against the delayed disclosure assertion by the state was limited. That the defense didn't have any of this information to bolster its argument that, okay, they waited until 2020 when this was actually occurring in 2018 or 2016 or 2019, or in KH's, the complaining witness specific to my case, in 2010. But it's not just the delayed reporting, it's the combination, or it's not just the fact that maybe children delay reporting, it's the combination that two of these children had mental health diagnoses that they were being medicated for with psychotropic medications, that they had a history of making allegations against other people that were investigated and proven to be untrue. And with regard to the KH allegations, the JFS records, which were not produced and then were not, so the defense was not aware of them, was that JFS actually investigated the 2010 allegations that were made either by her or on her behalf. The children's medical records do not identify who actually made that complaint, that her Uncle Mark, my client, was the one who raped and committed gross sexual imposition. It's unclear whether it was the caregiver that accompanied her to the hospital that made the report or whether she made the report. But regardless, the JFS records had completed an investigation, found them unsubstantiated. She was actually referred to Mayerson for that allegation. Mayerson conducted an interview. None of that was produced to the defense. And the Mayerson people concluded that it was unsubstantiated.
But the more recent Mayerson interview was recorded and played at trial, right?
Yes, and she denied anything going on in that Mayerson interview. The only evidence
Was the
that,
first one recorded?
I don't know.
Okay,
We don't have those records.
okay.
They were never produced, and the defense didn't know that they existed to ask for them, because the only reason we know they exist now was because we were allowed to review the JFS records on appeal. So, and then with regard to KH, the only evidence at trial that substantiates the claim at all that Mark sexually assaulted her was her interview with the police, which was introduced solely for the purpose of impeaching her. That's not substantive evidence. So her trial testimony was denied anything happened. Her Mayerson interview was denied anything happened. Well, we're going to impeach you with your statements that you made to the police and an entry in your phone notes. Those are not substantive evidence, and they should not have been admitted for purposes of substantive evidence. So there should have been a Rule 29 decision by the court. There's insufficient evidence to support those convictions as a matter of law. Now, with regard to the failure to sever the defendant's cases, as I said in the brief, about a year prior to the trial, both defendants moved to sever the cases from each other. The argument was these are not cases where the defendants acted together. There was no collusion to sexually abuse these children. There was no acting in concert. There was nothing that joined these defendants together so as to be tried together, and that was the basis.
Does there have to be collusion? I mean, they're both living in the same house.
Yes, but even the state acknowledged in opening statements, we are going to be trying these men separately. So they recognized that these were two separate trajectories of events. The problem is they didn't keep it separate during the course of the trial. They repeatedly argued these men, Mark and Daryl, their father and their uncle, it was a house of horrors. So they clearly made the argument that these two men were acting basically in cahoots, as if it was one part of a common plan. These were not co-defendants in a robbery or a burglary or a kidnap. These were two separate men charged with separate crimes that had nothing to do with each other. And the additional argument on behalf of Mark in connection with failing to sever, which the trial court even recognized as a possible issue, was during the introduction of phone conversations between Daryl Hammond and a third party, neither of whom testified at trial, during which Daryl Hammond says, well, Mark was always kind of overly protective of KH. I felt it was a little odd. And then also saying, well, if that happened, I'll have to kill, I'll kill him. So clearly, statements that were made against Mark's interests, introduced at trial by the co-defendant without any ability to confront him in violation of his right to confrontation. Any other questions?
Not for me.
Okay,
All right, you have 6 minutes remaining.
okay, thank you.
Good morning, Your Honors. May it please the court. I guess we'll take it in the same order that the appellant did. As for the JFS records, I think one thing to keep in mind here is that the records are statutorily protected in this case. It's not.
Well, right. But there's due process rights for the defendant, and the case law recognizes that. And just reading through these records, I have concerns about whether or not they received a fair trial based on the evidence that was withheld.
I understand the concerns, Your Honor, but I think in this case, most, if not all, of the concerns that were raised in the JFS records were addressed in other portions of the trial. The prior statements of the children came in through the testimony of KH. The children's medical records, the diagnoses were in the medical records that were placed on record with the court. And I understand that there is a due process concern, but it's also a weighing. And the starting point in these cases is that the records are confidential. And keeping in mind that this is an abuse of discretion standard that the court is applying, I just don't think that.
What about, let's go specifically to the Mayerson issue that Ms. Conkin was just talking about. The Mayerson interviews come in, the more recent ones. Right. So can you explain to me how the recent ones can come in, but the more dated one that is closer to the time where there's a conclusion that there's no substantiation, why that stays out and isn't turned over to the defense?
There's been no allegation of a discovery violation in this case, Your Honor.
No, I'm not suggesting discovery violation. I'm just saying, why under the principles that govern these records, why does one come in and the other one that reaches a different conclusion stays out?
For one thing, the Mayerson records aren't JFS records. Those are two separate avenues of what the defense was looking at. And the prior inconsistent statements or the prior consistent statements of KH came in through the previous Mayerson interview. There was nothing that was left out. As far as I know, all the material that was gathered from Mayerson made it into the record. So and one of the things that I think the court has to look at is that unsubstantiated doesn't necessarily mean untrue. when I was looking at the JFS records yesterday, one of the threads in these records is that a lot of these allegations didn't come to light, or they weren't fully investigated until there was a change in the children's caseworkers in 2020. So that, and one of the things in the records indicates that the prior caseworker, not to fault him or her, but it just stated that the facts weren't there to substantiate the claims, not that they were necessarily found to be untrue. So I think that in that sense, that the impeachment material or the impeachment value of that material would be greatly lessened in light of those. In light of that concern.
Yeah, I mean, it's not completely exculpatory in terms of like that never happened, but the converse to that is that when JFS finds substantiation, isn't that usually when they turn it over to the prosecutor's office and say, time to build a case on this?
And that's exactly what happened in this case, yes, Your Honor. But I think the important thing is that the records indicate that that maybe not for every allegation, but for a large number of the allegations, there was not a factual basis for JFS to go forward or to contact the prosecutor's office.
I guess where I'm struggling a bit is this case rested on the credibility of the witnesses, particularly the children. And these records, whether the allegations were substantiated or unsubstantiated, they definitely could have led the jury to consider whether these witnesses were credible. So I'm struggling a bit as to how it could be fair to keep that information from the jury.
Again, Judge, I would just emphasize that this is a weighing, and I understand the due process concerns that you're talking about. But I think that the concerns that were raised in the material from the JFS records, a lot of it really was covered in other testimony and other evidence that was put before the jury, and it would be hard to speculate what impeachment value that this would have had or what effect it would have had on the trial. But again, I would emphasize that this is an abuse of discretion standard, and I don't think that the appellants have demonstrated that this was an arbitrary decision for the trial court not to turn over these records, and I don't think there's been any specific showing of prejudice.
Let me follow up with that question concerning the JFS records, and I'm focusing on the mother, and I felt that defense counsel did a thorough job of cross-examining her, pointing out inconsistencies in behavior. For instance, the kids disclose and she reports it the next day or 2 days later. But concerning the materiality of one of her statements, where she apparently 2 days before the kids disclosed to her, she said, "Something is about to go down and you will see." And my understanding was that was contained in the JFS records. And I guess my question is, how would that not be material when the gist of all the cross-examination is mom's driving this, she wants the kids' Social Security, she's inconsistent, she's a liar, et cetera, et cetera. So let me ask you about that.
I'm sorry, Your Honor.
Yeah, no, go ahead.
I think that entire line of questioning, though, was pursued by the defense, and I think that the isolated comment that she made didn't really, I don't think it added a lot to it, because the allegations were that Ms. Davis was doing this in an effort to get the Social Security payments or to otherwise interfere with the custody battle. And I think that that's something that was fully explored. And I just don't know that one comment taken in isolation would have turned the tables or would have carried the day with respect to the impeachment or cross-examination of Ms. Davis. As for the other assignment of error, the medical records here, the Children's Hospital records are definitely in the trial record. They were introduced as substantive evidence under Evidence Rule 8043, similar to the arguments that we made about the Mayerson records. These were statements that the child made to a medical personnel for the purpose of diagnosis and treatment, so that the allegations against Mark Hammonds are definitely supported by substantive evidence in the record. There's been no showing that there was again, no allegation of any discovery violation in this case or in anything where the state is alleged to have hidden the ball, so to speak. As to the motion to sever, I would first note that, there are two rules that come into play here. Rule 8, which is joinder, and Rule 14, which is a motion to sever. And I would note that the assignments of error in this case relate only to the latter. There's no separate assignment of error, that these were initially improperly joined, and I don't think there can be any doubt that these, under Rule 8A and B, these arose out of the same or similar act or transaction, or based on two or more transactions that were connected together, as Judge Bergeron stated at the earlier. This arose from the same factual transaction. This was the same household, the same witnesses, the same investigators who would have been testifying in this case. I think Rule 8 looks at as if judicial economy will be served by the joinder of the cases, and I don't think there's any doubt that they would be.
But
in this case.
what is, and I agree that it all did occur in the same household, but what is your position on what is the level of connection that there has to be? Because say two people came in independently to the house, one robbed it, and then one came in the house and shot somebody, same household,
Yeah.
but no real connection there, probably we would say that's not appropriate to try those together. So where do we draw that line?
Well, I think here it's clear that the living arrangements facilitated these offenses, and that there was a connection between the offenses factually. I know that the example that you had, there would be two separate types of crimes that probably wouldn't involve the same kinds of allegations, but here I think the similarity is certainly sufficient under Rule 8 to promote. I think, as I said, I think what the rule is intended to do is promote judicial economy, and I think we have the same factual background, we have the same witnesses in this case, and I think it's definitely something that should have been tried together, and I don't think that there's been any showing of plain error in the trial court's failure to sever the cases. I think it met the simple and distinct act, and when it meets the separate and distinct act, there's no requirement for any limiting instructions.
Can I ask you a little bit about that, please?
Sure.
Plain error is a really big hurdle.
It is.
That being said, so with this simple and distinct evidence, reading through the record, it seemed to jump from evidence about JD, then about DD, and then it seemed to jump back and forth quite a bit with and that's understandable because the witnesses were testifying about their investigation and the interviews and that sort of thing. But it did seem to jump back and forth a bit, and then there were times when, and that's with the separate counts, and then there were times when the testimony and the arguments were about, more generally, this happened in this house and this sort of thing. So it seemed like there was some jumbling of the evidence and of the testimony about what happened.
I know what you're saying, Your Honor, but I think it's impossible not to have some sort of connection between if the offenses were completely distinct, we wouldn't have even wanted a separate trial. And I think that because they arose out of the same factual background, out of the same residence, or the same number of witnesses, there has to be some intermingling, or it wouldn't make any sense to have to try the cases together. But I don't think there was any case where one of the defendants made allegations against one of the victims made an allegation against one of the defendants where it was clearly inapplicable, or clearly meant to be applicable to the other. I think that the evidence was clear when the children testified in the statements to the Mayerson Center. They identified which person did what, and I think that satisfies any questions that the court would have about the motion to sever. And again, as the court said, it is a plain error standard, so I don't think we've met that in this case, certainly. Unless the court has any questions, I would just ask the court to affirm the judgment of the trial court.
Thank you.
Thank you. Ms. Conklin, you have 6 minutes.
And could you start with Mr. Satter's point that you guys got all this in through other means in terms of the substance of what's in the JFS records?
Well, I think the record is pretty clear that all this information did not come in. Otherwise, it would.
No, I recognize that the JFS records in and of themselves did not come in, but that the substance of information that you want to get in through those records came in through other means, and thus essentially it's harmless error.
Well, I guess my argument would be that many times the information that you get in records such as the JFS records alters the way you prepare for trial and alters the way that you create your defense. It alters the way that you handle voir dire. Would there have been more questions about the fact that what if you found out that a child had never reported despite multiple opportunities? Not just that there was a specific question, did your uncle ever abuse you? No, no, no. But that these had been observed by multiple people, not just one caseworker. Multiple people made entries into these JFS records. So it affects your ability to conduct voir dire, in your jury selection, in your opening statement, how you approach the other witnesses. Cecilia Freehofer would have been cross-examined more vigorously, I believe, had they known that these JFS records existed. She would have had to have defended why on multiple times, year after year after year, these children denied anything was going on. No physical abuse, no sexual abuse, no neglect, nothing. And that those all play into the defense's argument that these are not credible complaints. And that's why I think that these records were material, not only that they were material and that their absence is prejudicial to his defense. That there would have been so many more opportunities to cross-examine Desiree. She had not just a history in this case of, are we getting the children to make these complaints because of, I want their social SSI payments, but also there were prior examples where she had urged one of her children to make a claim against another man. There's even another man identified in these records, another brother, Robert Hammonds, that no one knew anything about, who had been accused of assaulting one of the children. So all of this information that was not addressed during the trial because the defense didn't know it existed would have definitely bolstered their arguments that these claims are not credible and certainly not proven beyond a reasonable doubt. Especially with regard to K.H., who was separate from Daryl's case. I don't think that this was a situation where the Mayerson records were specifically withheld from us, from the state. I think that no one knew they existed because they were so old. And no one went and looked for them. I don't even know if that interview was recorded. I don't know if there are any notes on it. I just know from the JFS records that it took place, and she denied the allegation. She denied anything going wrong with her uncle, Mark, any allegations of abuse during that interview. And that would have been material to Mark's defense in cross-examining both Freehofer and the police, as well as the opportunity to introduce prior consistent statements to rebut the inference that she had recently fabricated her denial. So this would have bolstered the defense's arguments that she lied to the police, that she was telling the truth before, at the time near the occurrence, and then at the time of trial, and also in her Mayerson interview. I would also like to argue that the change of the caseworker is irrelevant. There were multiple people who saw these children. It just wasn't one person that was in charge of them. That would have been impossible. But the JFS records show that many people made entries and many people were involved in their oversight. And so I think that's a non-issue. I think the JFS records might have prompted the defense to ask the judge for money to hire an expert. That there is enough information here to challenge Freehofer's assessment and conclusions regarding the meritorious claims, or whether the claims of the children were meritorious. As it stood at the time of the trial, all they had was Freehofer's report and, some inconsistent comments that the children made during that interview. But had they had these JFS records, which go into much more detail about the children's history of unreliable accusations, that could also have been an option for the defense. With regard to the improper joinder, I think in this case, the failure to separate the trial of the defendants was recognized by the trial court when one of these conversations was admitted into evidence. Out of nowhere, the trial court says, well, what, do you want to bifurcate the cases now? And both the defendants said, yes, we can do that, we'll do that. And then it was like the next second, well, we're not doing that. Motion denied. And so the trial court recognized that there were problems with this case in trying the two men together. These are separate claims. The fact that all of the children were allowed to testify back and forth, hopping from, your uncle, your dad, your uncle, your dad, and then that the prosecution argued that they were basically acting together, that this was a place, and if you look at my brief on pages 37 through 41, the opening statement, closing arguments, any opportunity the state had to make the pitch to the jury that these two men were basically acting together as a duo, as a pair in their treatment of these children, violated the statement that they had said before, which was these are separate and distinct cases against each of the men, and that you need to take them and you need to handle them as such.
Thank you very much for your arguments.
Thank you.
Your case is now submitted, and we will issue a timely decision. And if I could have the next case up. Ms. Glazer, would you like to reserve any time?
Yes, Your Honor, I'll reserve 5 minutes, please.
Okay, thank you. Whenever you're ready, you can get started.
Thank you. May it please the court, co-counsel. As I was listening to Ms. Conkin's arguments, I believe I heard the court have concerns about how the JFS records would have been used if defense counsel was aware that they existed at the time. And I heard the state say it's hard to predict what value the records have. And I would agree that the fact that they're confidential by statute does not mean that they shouldn't be turned over to defense counsel. You have 2 attorneys right now who have reviewed the confidential records in totality. Voluminous records. Trial courts have turned Job and Family Service records over to defense counsel during trial. It does not have any effect on their admissibility. But it's impossible now, and especially when you're in appeals court and there's this harmless error standard all the time, to go back and try to reinvent the wheel with this. But she was correct in that it would have absolutely turned around probably everything about the way that the defense presented their case. Everything from trial strategy, interviewing witnesses, whether or not they had investigators go out, opening statements, jury selection, impeachment, cross-examination of the children who testified. Without the physical evidence, that really is fundamental in this trial. And so I don't want to belabor everything that she said regarding the JFS records, but I do think that's an important point here. I would like to address some issues that I believe existed with the actual permitting the remote testimony and the way that it procedurally was done in the trial court.
And you're primarily making a statutory argument here, not a constitutional one, right?
I'm making it both, essentially. I'd like to start with the statutory argument first. So the state did file a notice that they were going to be using remote testimony, essentially a year before the trial. It's only required by statute to be filed 7 days prior to trial, but they made no indication to the trial court or defense counsel that they were going to move forward with the remote testimony. So,
Let me ask you, Mr. Glazer, wasn't that precipitated by, like, one of the witnesses essentially shutting down during the direct testimony?
so you have.
And the judge denied it originally and said she would revisit it, I think. So, do you understand my question?
Yeah, so if I understand your question, you're saying that the justification that the trial court gave for permitting the remote testimony was when Dee Dee.
One of them.
Sorry, I used first names in my brief because I found the initials to be cumbersome, but I wasn't sure if I was allowed to use first name only or not.
Yeah, let's not use that.
Okay. Dee Dee, according to the court, shut down, but I don't think that's quite evident from the trial transcript. And it's not my understanding that the trial court actually denied the request for the remote testimony prior to trial. I'm going off memory here. I don't believe.
Well, so am I. So.
Okay. I don't believe that was evident from the trial transcript. I don't think it was revisited by the state or the trial court when the trial began. Where I think the trial court is after Dee Dee testified for that first afternoon. The last thing that happened in the trial is that he drew a picture identifying the person that he said touched him. Trial ends for the day. The next morning, everyone comes back for trial, and the state says they're going to put on a social worker, JFS social worker, to try to establish what they have to under the statute, that the child will suffer serious emotional harm if he moves forward. The JFS worker that testified to that was someone who was affiliated with the children for a very brief amount of time. We're talking about months, and he basically said that he had social worker training through Job and Family Services, and then renders, basically he's asked by the prosecutors, will this child suffer serious emotional harm if he has to continue testifying in this trial? And he says yes, and that's the end of it. I mean, so the court finds.
But I mean, like, isn't that enough at the end of the day? Like, that's testimony by a putative expert here on the emotional condition of the child. Like, isn't that enough for the trial court to then start to evaluate other measures?
I don't think that, one, he was qualified as.
I know, I'm not as a technical expert, but.
Right. I don't think that he was qualified as an expert. I don't think that his testimony constituted lay testimony either. I think asking someone their professional opinion about whether or not a child would suffer serious emotional harm when they weren't even there the day before to observe the child testifying is a stretch. And one of the problems with not having the hearing on this issue prior to trial is that the defense attorneys are essentially ambushed when they come in that morning and the state says, we're going to try to put him on via circuit TV now. Usually when this happens, there's a hearing where you can present witnesses and you can cross-examine whatever expert or lay witness the state attempts to put on, and you can argue about whether or not they're qualified if you want your own witness to come in and testify. But because of the way it was done procedurally, they're kind of caught off guard by this, and then you see them sort of in the transcript try to fumble around with what they're going to do after he says this and the judge says, well, we're doing circuit now. And so they're in a position where they object, but they're trying to figure out how they're going to cross-examine this witness. And that's just for Datorian. So, excuse me, I'm sorry, DD. JD was never subject to attempting to testify. So we don't know whether or not he was capable of testifying live because he was never given the opportunity. But once.
Did the trial court have to do that to determine that he would have suffered trauma? I mean, does the trial court have to subject a child to that trauma before they determine that there will be trauma?
So the statute says, yes, that the court has to make one of these three findings. Whether they suffer emotional harm, I believe it's whether they persistently refuse to testify or whether they're just unable to. So I argue that the children should, if they've not had this remote hearing prior to trial, should be put on the stand and give live testimony. If they're not able to, then you could have a hearing. I still think that the defense was prejudiced by doing this, not in advance and during the trial. I don't think that the state met its burden.
Well, but I guess my question is, like, what's the trial court supposed to do? Like, if the trial court thinks this child can testify without harm, but then watches the child on the stand and is like, oh my God, like, this is causing significant harm to the child. I appreciate everything you're saying about, like, how this was unexpected, but can't a trial court take those measures once they see something that might change their perception over the child's testimony?
So if the trial court is in that position and they believe that they've seen enough, okay, and they order this remote testimony, even in that scenario, I still don't think that the defendants were given a fair shot here because the defense attorneys were not permitted to actually be in the room with the children.
Let me focus you in on that. I'm gonna paraphrase from the statute here. It says that the judge shall exclude from the room every person except the judge, one or more interpreters, the attorneys for the prosecution and the defense. But it says they shall exclude from the room anybody except those people. But I searched, and I didn't find any case law that says that the prosecution and the defense are required to be allowed in the room. So there's a little bit of a difference there. Am I missing a case? Am I missing something?
I did not cite a case for that proposition. My interpretation of the statute, as well as what I was able to find, is that the defense should be entitled, and that's just basically the right to confront. I mean, you cannot be effective as an attorney cross-examining someone through a circuit TV.
Well, let me ask you about that, because my understanding of this, it was that the children were in a separate room. I think one was at Children's Hospital, one may have been somewhere else, and the prosecutors were in the courtroom doing their direct examination. Your client was in the courtroom with his attorney watching the screen, and I guess explain how that's not confrontation. I mean, does it have to be in person, is the gist of that question?
So it's very difficult when you're reading a transcript to actually understand, and I know you as a trial court judge have probably seen this, but it's very difficult when you're in appeals court and you're trying to read a transcript and imagine how this actually unfolds. But I don't know, for example, if the witness was able to actually see my client or, Mr. Hammonds in the trial. It's not part of the record. And I think one of the reasons with being caught off guard is that the trial counsel was not able to properly put anything they observed about the circuit TV into the record. But they usually don't, I mean, this is not part of the appeal, obviously, but we don't know whether or not they could see the defendant. So the defense's theory is that the mother concocted these lies and planted the story with these child witnesses. You tell a lie about something that happens. How easy is it when you don't have to talk about it all this time, and you go into court, and now you have to actually say a lie against your father for the first time, and you're not able to do that, and then judge takes you, puts you on a video, you don't see him again. We don't know what's going on in the room. Is there somebody there that's high-fiving every time he says something? Are there several victim advocates in there? Is everyone like sitting there, saying, "Come on, you can do this"? It's a different dynamic, and I don't think it protects his right to confrontation. Is my light going off?
Yes.
All right. Thank you.
Thank you.
Good morning again, Your Honors. May it please the court. As for the first, Ms. Glazer touched on the 515317 issue about the JFS records. I would note that the statutory scheme contemplates an in-camera inspection followed by the trial court's evaluation of the evidence, and that there's no provision in the statute that the defense be able to look at this.
Yeah, I guess, and I realize there's not, but it's just like, it's bizarre to me that defense counsel at trial didn't have this information. Defense counsel on appeal does have this information, and they're able to make the arguments that they're making. It's a lot of material. Like, it would have made more sense for defense counsel at trial to have had that, and then they could have made the arguments to the trial judge and said, hey, this is why we need it. and focus the judge better than just saying like, sort through this stack of papers.
Yeah, maybe so, Judge, but I think that, you know, this court complied with the statute in that the defense has or the appellant has the burden of demonstrating prejudicial error, and I know that's a hurdle. It makes it tough, given the statutory scheme, but I think that's what we're left with. With respect to the remote testimony, I don't really know what more the state could have done to put the defense on notice. It seems to be that the complaint was that our notice under 294581 was filed too early. And I don't really understand how the defense could have been prejudiced by that. I think it's the nature of these kind of cases that some of it has to be done on the fly. You don't know how a child's going to react when they get on the stand. You don't know what other safeguards you're going to need to get their testimony. And in this case, I think the trial court, again, complied with the statute to the letter. You know, there's no requirement under 294581, as Judge Bach said, that the defense counsel be in the same room with the child. I think it's.
Do you have any case law either way on that?
I don't, Your Honor. I just think it's the plain language of the statute. I think if there had been a confrontation clause problem with it, certainly 294581 probably would have been challenged on that basis. And I just.
Well, I guess I read the statute as saying, shall exclude from the room everyone except. So to me, that suggests there's a right for those people that are in that except category to be there. And defense counsel clearly wasn't there. I mean, sounds like the prosecutor wasn't either.
Right. And I think, and part of this is that, as I said, I think some of this has to, and it was done with collaboration with defense counsel and the prosecution. The trial court had discussions with them that said, you know, how are we going to work this? And it seems to me in reading the transcript that the defense counsel acquiesced in the procedure that was done here.
Did they really have a choice, though?
Well, I don't know, Judge. You know, attorneys aren't shy. If they thought that this was a problem, they would say, at the very least, they could have said, Judge, I understand the court's position, but for the record, we're going to oppose what you're doing here because we feel it violates our client's confrontation clause rights, or it violates 294581, and that simply wasn't done here. And it wouldn't have taken a great deal to preserve that for appeal, and it wouldn't have been the kind of thing where we would have to antagonize the judge to do that. I mean, it seemed that there was a good rapport between the judge and defense counsel, and it wasn't the kind of thing where the trial court says this is the way it's going to be, tough luck. The tenor of the transcript just is not.
Well,
like
I mean, I reread that portion of the transcript yesterday, and it seemed like, and I can't remember if it was the attorney for Mark or for Daryl, but the attorney did say at least once, possibly twice, that she wanted to be, or I can't remember who represented him below, but the attorney said that they wanted to be in the room.
And there was some discussion of that, Judge, and there's no doubt about that, but I think where it was left was that there was an acquiescence to the procedure that was chosen by the trial court. There was certainly no renewal of an objection on that score, and I just think we're left with plain error at most. The standard of review would be plain error at best, and I think that it might be just that the issue is forfeited altogether. The court had some questions about requiring the child to testify before invoking 294581. There's a case from this district, State v. Gresham, cited in our brief that indicates that the trial court is not required to put the child through the trauma before invoking the remote testimony procedures in 294581. Other than that, unless the court has questions, I'm going to rest on my brief, and I'll ask the court to affirm the judgment of the trial court.
No questions.
Thank you.
Thank you.
You have 5 minutes.
Okay, thank you. With respect to how the situation was handled regarding the right of the attorneys objecting to being in the room when the child's testifying remotely, I think the trial court's response was, we should go with how we've done it before. And so I think they properly objected prior to the court saying that. That's the court's ruling in response to the objection, so I would argue that it's abuse of discretion analysis rather than plain error. The State versus Gresham case, as well as the other cases cited by the state, Sabata and Walters, in all of those cases, they actually held a hearing prior to the trial. They had, for example, in Walters, the testimony of a nurse practitioner who had conducted the physical exam of the child. She had training, education, experience. She was admitted as an expert in that case, and she actually found physical tears that she testified to during the exam. That was all presented prior to trial, and I think the procedural posture that was followed in those cases is much different than what actually happened here during this trial. I would like to touch briefly on the severance issue. So I don't think there was any exception under 404B for these separate acts to be tried together. I don't think there was anything to show that there was a scheme or a plan. And I know the state argues that I conceded the simple and direct portion by arguing that these acts were separate in time, separate children, separate allegations. But the argument is that they could have been simple and direct. It was but for the fault of the state. So the way that they presented the case is what made them not simple and direct. And because the presentation of the evidence was the way that it was, I don't think that my client received a fair trial.
And I guess, help me understand that, because are you just saying that the state didn't draw a bright line around this allegation versus that allegation?
So the testimony itself is very vague with respect to all of the child witnesses. There's no timeline about when the acts occurred, especially with ND. ND was the only witness who was able to basically even put a timeline around the age of when it happened. So she says initially a touch happened when she was 5 or 6, and then nothing, and then she was touched again at 12. DD was not able to establish any timeline for when any of the acts happened, not through the 2 Mayerson interviews that came in, not through the trial testimony, and he was 12 at the time of trial. And then JD, who was 11, was not able to put any timeline, not an age, not even, typically what you see in these cases is where they'll say, well, it was around my birthday party where I got the big doll set, or it was in the summer when I went to stay with my Aunt Lily. There's some kind of description on the timing. All of these child witnesses were very vague, and then the state then presents, well, these 2 brothers lived together during all of this time, this is a house of horrors, and presents it as though they're acting in tandem, when in fact both of them have a separate child witness who says nothing ever happened with that person. And I just think because there's no physical evidence and the testimony was so vague with relationship to what happened, it was pretty much all over the place. I think the state presented it in a way that made it confusing and it was prejudicial. If the court doesn't have any other questions, I'll submit.
Thank you. Your
Thank you.
case is now submitted, and we will issue a timely decision. Have a nice rest of your day. Next, we have State versus Watts. Ms. Nelson, would you like to reserve time?
Yes, Your Honor, 4 minutes, please.
Whenever you're ready, you can get started.
Good morning, Your Honors, and may it please the Court. Good morning, opposing counsel. Sarah Nelson again on behalf of Ms. Watts. This morning, I intend to focus on the first assignment of error and submit on the second assignment of error concerning sufficiency and weight. Of course, if the Court has questions, I'm happy to answer them. Regarding the first assignment of error concerning the motion to suppress hearing, The trial court was incorrect in this case when it denied the motion to suppress on the basis that the defense did not meet its burden in establishing that this case, demonstrating the lack of a warrant in this case. And it's my position that that decision was incorrect for two primary reasons. First, the trial court's decision was based primarily on this court's opinion in State v. Newell. And in that case, the parties submitted on motions alone, which is a significant distinguishing fact between what happened in Newell and what happened in this case. The burden did not shift in Newell on the demonstrating a lack of a warrant because you can't shift the burden on motions alone. And in this case, trial counsel did develop testimony from the officer surrounding the circumstances of the stop. Again, trial counsel, in its motion to suppress, argued that this was an unlawful stop and demonstrated the unlawfulness of the stop in the direct examination of the officer. Which brings me to my second point. Demonstrating the lack of a warrant can be done through testimony, circumstantial evidence. And we have direct testimony from this officer that tells us nothing about what happened prior to the stop. So we have no predicate traffic offense. Circumstantially, we have no warrant. I think the testimony in this case is sufficient to demonstrate the lack of a warrant, and the trial court's hyper-technical application of the demonstration of a lack of a warrant was improper in this case. We don't need to, while it might be best practice to ask, was there a warrant, that golden question isn't necessarily required if you can show through other means that the stop was unlawful because it was conducted without probable cause, without reasonable suspicion. Xenia v. Wallace supports this position, and I'd like to point to two significant things about that case that I believe supports what I'm arguing. First, at the end of the case, I think it's the last paragraph, the court talks about how the defense counsel in that case, in its questioning of the officer, focused its questions as to the reasonable suspicion for the stop. There's nothing in that case that says you have to specifically ask, was there a warrant in order to shift the burden? So I think that supports that circumstantially the evidence and the testimony can show that there was no warrant in this case. And second, that case dealt with, was the prosecutor sufficiently put on notice for them to respond, to put evidence on to meet its burden of production? And the court, in analyzing whether or not it was fair to put the burden of production to produce evidence as to the legality of the stop, the Ohio Supreme Court made two important notes. Primary access to the evidence is within the state. So if there was a warrant in this case, the state's going to be the one who knows about it and has access to it. Presumably, the defense counsel was never made aware of a warrant in this case, which is why they focused their testimony.
There's often not a whole lot of warrants with traffic stops.
Exactly, I agree with that. Presumably, there was no warrant because I can recall one time, I think, where I've ever seen a traffic stop preceded by a warrant, and they also had a speeding violation. So it's very, very rare where a traffic stop is preceded by the existence of a warrant. But again, that information is within the purview of the state, which is why I think circumstantial evidence is sufficient to shift the burden.
And there's some of the testimony I think that's discussed in the briefs occurred at the trial as opposed to the suppression hearing. Are we able to consider what happens at the trial for purposes of evaluating the suppression issue?
No.
Okay.
And I am sorry if I conflated.
I don't know, like maybe I got conflated.
So,
but-
yeah, I mean, and it's an interesting thing to point out because we do know, so the prosecutor's questions to the officer in this case on cross-examination are in generalizations. The prosecutor doesn't directly ask, so the prosecutor does ask, generally speaking, when you pull somebody over, do you always document in the citation whether or not there was a speeding violation or some other infraction? And the officer says no. Sometimes, generally speaking, I will give them a verbal warning. But that doesn't relate to reasonable suspicion to stop this client, which is what the Fourth Amendment requires. At the trial, we do know that the officer did not recall why he pulled Ms. Watts over. Now, we can't consider that for purposes of motion to suppress, but we do know that there's a gap here and why. And the motion to suppress hearing doesn't develop that fact as to why. Just taking the motion to suppress hearing by itself, there's nothing to tell us what happened prior to pulling Ms. Watts over. We just know the ultimate result is she was charged with driving under suspension, which is another point that I'd like to point out in Xenia v. Wallace. In saying that the state has the ultimate burden of producing evidence as to this point to prove the legality of the stop, the court says that it's less burdensome for the state to prove probable cause because they do have access to this evidence, whereas the defendant is being charged with proving a negative. it's so much more burdensome for the defendant to have to figure out whether or not there was in fact a warrant here, there was in fact probable cause. That's particularly true in this case where we have no body-worn camera and no motor vehicle camera evidence. We just have the citation. And those are my two primary points that I believe, honestly, this trial court just applied a hyper-technical application of the burden to demonstrate the lack of a warrant. That can be done by circumstantial evidence. I'm not going to reiterate all those points again, but if the court has no questions, I'll just reserve the remainder of my time for rebuttal.
Thank you.
Thank you.
Good morning.
I guess I'll start by saying that Xenia v. Wallace applies to traffic offenses. And in Newell, it's the same thing. Yes, Your Honor, it's rare. It's a rarity that there would be a warrant in a traffic stop. And if we get past their burden of production, very difficult for me to establish probable cause.
Yeah, I mean, like
Stop.
the officer had no recollection of why the stop was
Absolutely.
executed.
And it was an exceptionally simple fix. It's not an onerous task. It never has been. The trial court even attempted to address it before the witness was called and said, is there a stipulation as to a warrantless arrest? And trial counsel said, I can say, Judge, we are prepared to put the officer on the stand and let him discuss why he stopped Ms. Watts.
Why didn't the state just stipulate that it was a warrantless?
There was never a request to stipulate. I believe the state would have stipulated in such a situation. And I think that if there is a stipulation with a lack of probable cause that was elicited, the result could be very, very different. However, until that initial burden of production, and this is very similar to Newell. Newell was a traffic matter as well. The state was going to be unable to put on any evidence. Our witness was not there. And there's still that minimal burden, that minimal hurdle to reach of saying whether or not there was a warrant. The defendant knows full well, and the defendant could have in Newell, I believe there was discussion that the Fifth Amendment isn't implicated because anything that's said at the motion to suppress wouldn't be able to be used against them in the trial, and the defendant could have gotten on and said, yeah, they never showed me a warrant. There was no warrant. That's sufficient burden on the state.
Was there any, I'm trying to recall, was there actually a suppression hearing in Newell? Or was it just on the papers?
They did not hold one, no.
Right.
It was, you can't go forward, you don't have a witness, we're dismissing. And the court said, no, you can't do that until they meet the burden of production. And in this case, now we're trying to shoehorn evidence and say that evidence existed that from which we can infer a warrant. And Xenia doesn't talk, in no case that I'm aware of talks about inferring the existence of a warrant just because it's not likely to have been there, just because it's not likely to have happened. Defense counsel I believe it was in the rebuttal portion, or when discussing this, said there was no testimony one way or the other as to the presence of a warrant.
So if the defense counsel would ask the testifying officer whether there was a warrant, you would have a different argument?
Absolutely.
If he said no?
Yep, absolutely. It would make my job exceptionally hard to defend if the trial court had denied the motion, if the burden of proof had been shifted to the state. There's no question that specificity was sufficient. That's what Xenia deals with. Xenia doesn't deal with circumstantial evidence establishing that a defendant has met the burden of production. Xenia specifically says, assuming there was a warrantless arrest and assuming this. Xenia didn't deal with the burden of production. Xenia dealt specifically and exclusively with specificity, and that's what it has always been cited for.
But are you saying this motion to suppress was specific enough? In the written motion to suppress?
Yeah, as to putting us on notice that they were challenging probable cause for the stop, absolutely.
Absolutely.
That it was specific enough.
Okay. All right, thank
To
you.
establish that they were challenging probable cause. But to say that it's sufficient in all motions to suppress on Fourth Amendment are challenging probable cause. That's always going to be the case. That's not sufficient to establish the burden of production to just ask that one simple question.
Yeah, and I mean, I guess so, like, if the trial court agreed with everything you're saying, like, why did the court even hold a hearing? Like, shouldn't the trial court have just said, you haven't met your burden, and therefore there is no hearing? Like, you lose your suppression motion.
Well, until the close of testimony, the trial counsel could easily have just asked that, oh, one more question. Was there a warrant in this case? So it was necessary to allow them to have the opportunity to put on that testimony. And I think that the trial court, I think you can read in what they're saying is being reluctant on this, but the burden never shifted. And the trial court correctly cited Newell, correctly stated that. And I don't think that it's necessary for this court to step in and read into Xenia something that's never been there, something that's no other case cites for this circumstantial standard when the fix is already there. The fix is very, very simple, and it's for trial counsel to just ask that one question, or for there to just be a stipulation ahead of time, which routinely happens in such cases, particularly if all the parties know going into this that the officer doesn't remember the actual stop. A stipulation as to a warrantless arrest, particularly when the trial court asks, is there a stipulation? That would have been a very simple fix of this. I don't disagree that if this is dispositive of this issue. I'm not saying that we would have won either way in this motion, that this is dispositive. Xenia presents a very simple, a very low hurdle. It's kind of like admissibility. It's a very low hurdle to meet, and that should not be forgiven in traffic cases because it's rare that a warrant is used. It is still a burden that must be met, if there are no questions. Thank you.
Thank you.
Just to clarify, the trial court judge did ask, are you stipulating that it was a warrantless stop? And the prosecutor said, we're prepared to put the officer on the stand to explain why he stopped Ms. Watts.
Was that the prosecutor or the defense attorney?
That was the prosecutor.
Okay, because that's what I thought originally. Opposing counsel said it was defense counsel. I'll take a look at it.
Yeah, it's at page 21 of the motion to suppress transcript, and it's the prosecutor who says, we're prepared to put the officer on the stand to let him discuss why he stopped Ms. Watts. Then the trial court in that instance should have been, that wasn't my question, are you stipulating yes or no? That would have cleared up everything. But then we get into this awkward procedural posture where the defense goes first. So I've had that happen before in a case where the defense goes forward without a stipulation, and in dicta, this court says that it's cleaner for the record and it develops the case more thoroughly when there is a stipulation and the prosecution goes first. I didn't cite that case in my brief, but I have had it happen before. I've also had a case where the parties submit on body camera alone. There was no question from the officer in that case. Testimony, was there a warrant for the search of the vehicle? That question is never explicitly required in the motion to suppress cases that I've had. A lot of the times it's just assumed that there was no warrant because the parties just skip to discussing the facts surrounding probable cause and reasonable suspicion, which is why I relied so heavily on Xenia in this case, Xenia v. Wallace, because there is this discussion that the trial counsel's questions in that case were targeted about the reasonable suspicion going to intoxication, because that was an OVI case, right? So for those reasons, I believe that circumstantial evidence is sufficient to demonstrate the lack of a warrant. Just like circumstantial evidence is sufficient to prove beyond a reasonable doubt an element of offense, it's certainly sufficient to demonstrate the lack of a warrant in a motion to suppress hearing where the burden is much lower than beyond a reasonable doubt. And based on the discovery in this case, or the lack thereof, because I believe in early discussions about discovery, all that defense received was the citation. So if defense counsel leads with asking, was there a warrant in this case, and the officer says, no, or I don't recall, that creates a problem because defense counsel can't cross-examine that or follow up on that with things that they're not aware of. All they have is this citation. That's the only direct, objective evidence of what happened in this case. And I don't think it's the fault of the defendant for not asking that golden rule question. I keep calling it a golden rule question, but it's just, I keep thinking about it as best practice. The defendant could have asked this question, but they don't need to.
Did the defense counsel say something to the effect of, why did you pull her over?
No, defense counsel went through the citation
Right.
very thoroughly and said, here are all the opportunities where you could have cited or added additional remarks about what happened. And noted the fact that we don't have body camera, we don't have motor vehicle camera to confirm or deny what exactly happened in this case. All we have is the citation. So again, the defendant's burden is to just put forward sufficient evidence demonstrating the lack of a warrant. It's not proof beyond reasonable doubt that there was no warrant in this case. It's just a demonstration. They just have to persuade the finder of fact that there was no warrant in this case. And then the other part, as my adversary points out, is was the state sufficiently on notice to address the substantive claim, which is that this was a unlawful stop based on lack of probable cause, based on lack of reasonable suspicion, which they agree they were sufficiently put on notice of. Interestingly, though, they don't actually develop the record on that point. So if this court agrees that there was sufficient evidence to demonstrate the lack of a warrant, then it not only should reverse the trial court's decision, but it also should remand with instruction to grant the motion to suppress because the state didn't develop the record at all as to why this stop was lawful. There was no information in this case about any sort of predicate traffic offense. The state didn't follow up with, hey, we did have a warrant to stop this vehicle for whatever reason. It just questioned the officer on generalizations that don't sufficiently prove reasonable suspicion to pull this vehicle over, reasonable suspicion into Ms. Watts, or probable cause to stop the vehicle. Thank you, Your Honors. I respectfully request that you reverse and remand.
Thank you, counsel. This case is now submitted, and we will issue a timely decision. Okay. And then could counsel for Trinity Aviation versus Northside Bank please come up? Okay, Mr. Fecker?
Fecker, correct, Your Honor. Thank
How much time would you like to reserve?
I'm going to reserve 10 minutes for rebuttal and to respond to Appleby's arguments. I believe we're limited to a total of 15 minutes.
Yes, that is correct. So you want, okay. And then would you like to reserve time as well to, since you are a cross appellant?
Yes, Your Honor, 5 and 10.
I would 5 and 10.
I'll do the same, Your Honor.
Okay.
You're going to do 5 for your argument?
Yeah.
And 10 on rebuttal?
10 and 5?
I'm first, 10 and 5.
Okay.
Thank you, sorry.
She's more than welcome to take 5 minutes.
Okay. So at 4 minutes, I will press the yellow button
All
for
right.
you then.
Thank you,
Okay.
Your Honor. Good morning, Your Honors, counsel. I'd like to first address an issue about who are the appellants in this case. While the trial courts and the appellants have referred to them as the A&A parties, the relief requested hearing is for A&A Recycling, which is a party. The parts are moved for A&A, and A&A owes the money for moving the parts. The issues presented by my client is very simple. When a substantial amount of personal property is being moved, there is a cost to the movement of that property. Throughout this litigation, we have made the claim that these costs were incurred as an element of our damages and that they should have been awarded. An award for the labor costs should have been awarded after Judge Martin stated, labor is compensated. The labor costs should have been awarded when Judge Martin stated, there are now bills for the movement of the parts, and the moving expenses are assessed against Northside Bank in their actual amounts. He made that statement in his November 27, 2018 letter decision, which was incorporated into December 17, 2018 final judgment entry. The labor costs should have been awarded when the party stipulated that the parts were moved by and or on behalf of A&A. That's joint stipulated of fact number 10.
I I understand what you're saying, but it sounds to me like the issue was not whether or not these damages are a component that can be awarded, but more you guys didn't have the proof, according to the trial court, to substantiate that, because trial court found that the evidence was speculative or remote, or whatever the trial court said. And as I see the evidence, it's this one invoice with really no detail. So like, why did the trial court get it wrong on that basis?
Well, there was the invoice, and attached to the invoice was a supporting document that identified each laborer and the amount of hours they worked. And so we had a document that set forth the total number of hours that were expended. And then Mr. Filippo, and the party stipulated, his companies provided the laborers, said, I bill these laborers out at $70 an hour, and therefore it's a simple mathematical calculation. When you take the total number of hours worked times $70 an hour, that's $101,000 that we are requesting. And on that $70 an hour issue, the receiver hired a moving company to move the parts, and the receiver was billed $91 an hour to move the parts, and that bill was paid without any objection by Northside Bank and Trust. So we are asking for less as an hourly rate than the receiver did, and Northside are eventually paid by the prior court order without any objection.
The bill was like 2 years after the issue, and it was like prepared for purposes of trial. I mean, it was sent to counsel, right?
It was sent to counsel, and again, Your Honor, when we entered into a contract with Northside Bank, it was to purchase the parts. And in the prior appeal, on your decision, said there was a contract to purchase the parts.
I remember it well.
But that occurred, we filed a motion to say, hey, those parts are ours, we've purchased them, and Northside Bank, instead of saying, you're right, they were purchased by A&A, said, no, there is no contract. And if we had purchased the parts and Northside Bank had said, yes, they had purchased the parts, then there would be no need for us to issue an invoice at that point in time, because that's all on our cost. It was only after Northside breached the contract repeatedly that we had to then find the records, which we did, generate the invoice, which we did, and don't allow Northside to escape its responsibility for fully all the damages that it caused, because that process took years for the first court to decide. That's not our obligation. When we have been told, you've purchased the parts, and interestingly, when we filed our motion to respond, our motion to approve the sale that we had bought the parts, Mr. Lieberman for Northside Bank, who was the workout officer, said the response should have been, yes, we sold them the parts, instead of the response that was actually filed that says there is no contract. And so don't punish us because we incurred this labor and relied upon a contract that this court said existed, and then say, well, you didn't issue the invoice for 2 years later. If you've purchased the parts and they're your parts, you're not issuing an invoice to anybody to move the parts. It's only after the trial court and Judge Martin decided there was no contract that we then had to assert the claim for the labor that was cost. Now, the same could be said for the trucks. We incurred all those expenses in 2012, and yet we billed them in 2014, and both courts awarded us for those laborers, or for those trucks and those moving expenses. It's not like, you know, I don't know what, the judge said, Judge Nestor said, the first trial court said they were speculative, blah, blah, I forget the exact frames. But that does not exist in any decision by Judge Martin. Those words do not exist.
Why does that matter? Like, what we're looking at is what Judge Nestor decided.
Well, Judge Nestor decided that in the first trial court, we had not proven our claim to those expenses. And we submitted by stipulation the testimony of Donna Thornton and the exhibits to justify those expenses. So Judge Nestor should have made his own determination of those labor costs, rather than referring back to the first trial court and making up what the first trial court did and said, because the first trial court did not say that. The first trial court again, as I stated, said labor is to be compensated. There are now bills due for the movement of the parts, and the moving expenses are expensed against Northside Bank in their actual amounts. Judge Nestor said, as a finding of fact, said the move took substantial manpower, required 15 to 20 employees from Filippo's company, Holland Roofing. He also stated that the A&A parties satisfied their burden of proof to recover their reliance damages in this case. The A&A parties are entitled to compensation for the costs and expenses incurred to move, maintain, and protect the parts.
Let me ask you this, Mr. Fechner, maybe your time.
No,
can
I
ask you
actually
later.
let it go long. I'm going to let you go longer too because I was too interested in your argument.
When your client have had to move these parts anyway,
We would have
right?
had to move the parts.
If Northside said, yep, they're yours, go ahead and take them.
And we would not be here today to recover our reliance damages incurred if they'd said they're your parts
Right?
and you're free to do with them what you want. They would have not have been breach of the contract.
But wouldn't you have to move them anyway? Say, back the 2 years prior, you would have still incurred that expense.
Correct, but we would not have asserted that expense against Northside because we will have moved our parts. They're our parts, and we would have moved them
Right.
at our expense and not tried to shift that expense back to Northside. It's not a situation, and let me finish this up real quick. It's not a situation where Northside, yes, the parts are yours, and you could do what you want. We said, well, we've incurred $100,000 to move the parts. We didn't think it'd be that much, so we want you to pay $50,000 to move the parts. We would not be here if Northside had said, they're your parts. Thank you.
Thank you. I gave him an extra 3 minutes, again, because I got too caught up. So I will give you an extra 3 minutes. Would you like that at the front end or the back end?
At the back end, Your Honor.
Okay, you got it.
Your Honors, Mike Galasso on behalf of the Northside Bank and Trust Company. I'd like to go back in time somewhat because all of this occurred in the summer of 2012 is when this first occurred. And essentially what happened is that there were these emails where A&A bid on certain parts and then subsequent events happened with respect to the parts being moved, commingled with other parts. The email terms were that a secured part, well, that a bill of sale, a clean bill of sale would be provided is what the language was used in the emails. Ultimately, what began to happen, because when this occurred, everyone knew that there was some Comair inventory located in the warehouse. And everybody knew that that wasn't part of the collateral, that that wasn't being bid on. So that was known to everyone. But what everyone did not know is that multiple parties would later come forward after these parts were commingled and claim that they were there either on bailment or consignment or that they owned them. The landlord claimed certain things, and there were just multiple claimants to the parties that would need to be noticed in order to have a correct Article 9 sale. And you really couldn't have a correct Article 9 sale unless you had a secured party. If they actually owned it by bailment.
And I understand all that, but like you all still committed to sell it to them, so like
Yes.
your fault on due diligence or lack thereof in terms of not figuring that out on the front end, which is how we got to the last appeal.
Correct, Judge. And so that's what I was getting to, was that a receiver was needed in order to sell these parts. So what this court then determined was the issue of contract formation, that the emails constitute a contract. And then if you look at paragraph 25 of the opinion that Judge Bergeron wrote in 2020, it says that, you know, we're
Some of my best work.
Well, I actually remember from that oral argument that when Mr. Fecker was in his rebuttal time, that you said you realize that if you undo the unjust enrichment here, you have to come in and prove the contract claim. And Mr. Fecker said, yes, I understand that. And so that's why we had the second trial. The second trial, the way this court sent it back, was only with the issue of contract formation. So then the issue becomes, have they proved performance on their part and breach by Northside, and then damages. So those three things have to come. This court only decided contract formation. So I know I only want to limit myself to the claim for the extra $101,000 in moving expenses as to this part of my argument. But as Judge Bergeron said, there was no invoice for any of those claimed expenses until May of 2014, 2 years later. The invoice was never sent to A&A. It was never paid by A&A. Only one employee listed on the invoice was a party not of A&A, but of any of the other parties that had been involved in that case. And the actual cost of the labor was approximately $17,000, not $101,000. And one of the reasons that it was rejected was because the way these parts were stored is they were palletized and then put plastic over them. They weren't treated as scrap and just moved at a scrap price. So essentially, what you've got is a situation where it's manifest way to the evidence here was the trial court wrong in not awarding this particular component, because the appellant received every other element of their claim of these expenses except that. So the question is that wrong? And I would posit that it's not against the manifest way to the evidence, that these things were not foreseeable or the proximate cause of any breach by Northside, that the evidence just doesn't support that, and that there's not a sufficient basis for the Court of Appeals to then substitute its judgment for the trial court. And that's all I have, unless there's any questions.
Are you going to do your argument
Yes.
now?
Typically, you would do
yes.
your cross-appeal argument now.
Okay.
Yeah.
Thank you, Your Honor. I thought Mr. Fecker was next. So, the primary issue for us in this appeal is whether Northside breached its contract here. And if you look at the decision basically finds that Northside breached its contract by not delivering the parts, which it was unable to deliver, or by supporting the receiver's sale motion. And so our position throughout this has been that the receiver is an officer of the court, just like a magistrate. They're appointed by the court, subject to the orders of the court. ComAir filed a sale motion, A&A filed a sale motion, the receiver filed a sale motion. Northside didn't file a sale motion, but we took a position and we said that we thought that the receiver's sale motion was the best. Ultimately, the court ruled that way.
Didn't your client request the receiver?
Yes, Your Honor. We requested the appointment of a receiver, but that was with the agreement of A&A at the time. And their prior counsel wrote a letter and said, we understand that you can't deliver the bill of sale due to Gary Post's commingling of the property. And he specifically said in that letter that none of this was foreseeable. No one anticipated that all of these facts would occur such that we would not be able to deliver the clean bill of sale. And so the goal was to use the receiver to do that. But the goal, and this was addressed in Judge Bergeron's opinion in 2020, this court expressly rejected the argument that they bought everything wherever it existed. The formation of the contract was only to what was bid on in the two lots, and only that would be part of Northside's collateral. And there's just no way to prove that, and that was our position. We don't know what they bought because it's impossible to ascertain. So we believe that holding Northside liable for breach of contract here is essentially imputing a court order. That's the proximate cause. The court heard the positions of all the parties, ordered this property sold, the sale was conducted, it was confirmed, distributed, the receiver was terminated and discharged, there was insufficient money to pay the claims of creditors, and so Northside was without a distribution just as every other creditor was. There was actually a deficiency of about $75,000 between the net proceeds of sale and the cost of the receivership, and that had to be paid by Northside as well. So to additionally come in and pile on the cost of essentially A&A fighting with the receiver for an extended period of time, that's just not foreseeable, nor is it the proximate cause of the damages. So originally at the first trial, there was, the trial court declined to award 10 months of the expenses.
Didn't you all object to A&A's sale motion and say there was no sale to A&A?
We objected to them purchase, yes, Your Honor. We basically said that there was not a meeting of the minds, that we couldn't identify this material, and that's what the first trial court ruled, that it was impossible to identify, and so there was no mutual assent meeting of the minds in order for contract formation. This court determined that that was incorrect, that the emails constitute a meeting of the minds, but it's a problem of proof. It's going to be on the burden of the person asserting the breach of that contract to show what was purchased and for what price. Because remember, this was purchased as scrap, so it had to be weighed, and then based on the composition of the scrap, certain amounts would be paid for certain items. And that never occurred. The items were never weighed and paid, and all of these subsequent events necessitated the appointment of a receiver. But what we were specifically concerned about is that foreseeability is measured at the time of the contract. So this is back in July of 2012. Just as A&A said, no one could foresee that this battle would ensue over this period of time. And in fact, at a certain point, when these materials were held in Kentucky and the receiver was unable to get access to them due to a dispute with A&A, there was a motion to compel compliance in the trial court. And so the trial court specifically said, we are not giving you 10 months of those storage expenses because you created that situation by your own conduct. Later, when we had the second trial, the evidence was never different on that point, and without any explanation whatsoever, the trial court removed
But isn't, and I may be jumbling the facts, but like, once they believed there was a sale and physically moved all the inventory to their warehouses or whatever, at that point, then all the stuff happens with the receiver, and so it prevents them from doing whatever they were going to do with the parts, because now there's a legal proceeding about these parts. So they really had no choice but to sit on them while the legal proceedings were playing out. So like, how is that not foreseeable that if it's wrong and they had those parts to begin with, there would be cost incurred with respect to that?
Because once they lost those items, once the trial court ruled against them, that's when those 10 months accrued. That was after the sale order was already put on. And things had been moved to that facility that clearly were not things that they bid on. So for example, there's another case that made it to the Court of Appeals here with Comair, where some of their material had been commingled in with this. This is part of the reason for the receivership, that material then had to be extracted back out. So what we're saying is that it's not foreseeable at that period of time that once they lose that 10 months comes on top of it, where they're just basically, for lack of a better term, in contempt of court. They're just non-compliant with the court order, yet they're being rewarded for that 10-month period of time. And the evidence never changed on that point between the trials, first and second trial, yet when we get the decision, it's basically the unjust enrichment damages calculation again, but add the 10 months back. That's the difference between the two judgments. Now, A&A.
If you'd like to reserve your time, you're at 11 minutes right now.
Okay, thank you.
Thank you.
The fundamental flaw in all of those arguments is Northside fails to remember or appreciate the fact that it repossessed the collateral prior to filing the suit against Trinity and filing to request the appointment of the receiver. It was its property at that point in time. It was not the receiver's property. It was not Trinity's property. Judge Nestor made that as a finding of fact. After the note matured, Trinity did not satisfy the obligations of Northside, and Northside took possession of and engaged in efforts to liquidate the collateral. That's finding of fact number 2. As this court is well aware, and as the receiver testified, you can't sell what you don't own. They made efforts to sell the property, and therefore they owned it. When all this started to occur, there was a letter prepared by Mr. Galasso. It's Exhibit 130. That letter stated, Northside wanted the receiver to confirm that the property is all collateral pledged to the Northside Bank and Trust Company, and does not belong to one of the various parties that claims to have left inventory with Trinity Aviation LLC in one form or another. So that's the letter that started this process. They never asked the receiver, go out and tell us what property is our collateral and what property is not our collateral. That never occurred. They were told by the receiver, this stuff is worth millions of dollars. And instead of telling the receiver, we don't care if it's worth millions of dollars, we've sold it to A&A. We just want you to tell us what is our collateral, our property, and what is not. Instead of telling the trial court at any point in time, this is our property, Your Honor. We just want the receiver to exercise control over other Trinity property, but we have repossessed this collateral. It is our property. They never made that disclosure because dollar signs, millions of dollars are going to come our way. And therefore, we will disavow that contract, the contract that this court found existed. And so, when we talk about the breach of the contract, that's breach number one. Not telling anybody, this is our property. And again, when we filed our motion to say, Judge, we have bought this, the workout officer testified, we should have said, yes, Judge, we sold it to A&A. Now, he did that upon cross-examination when confronted with his deposition testimony where that's how he testified. At the trial, he first says, oh, no, this was all ours, or that we hadn't repossessed it until confronted. To this very day, in their brief, they refuse to acknowledge what they've done. This battle that was fought over who's selling the collateral was initiated by them, not us. We said, Judge, we bought it. They said, no, you didn't buy it. I am stunned to this day that they don't recognize that. And they try to blame us and other people. They did not need a receiver. You know, they mischaracterized their own pleadings. When they filed the motion for the appointment of the receiver, they never said, hey, Judge, we've sold this property and we need the receiver to issue a bill of sale. Those words are not in that motion for appointment. For them to argue to this court, that's why they requested the appointment of receiver, is their spin to try to continue to avoid their liability and obligations for their for the damage they have caused. Moreover, the receiver could not issue a bill of sale. It wasn't the receiver's property. It was their property. And all they wanted the receiver to do is tell us what's our collateral and what's not. And on the Comair litigation that they talk about, the other case before this court, they filed pleadings in that case and took the position that Comair did not have a perfected security interest in this property. And we requested in docket, we filed a request for judicial notice, which is docket 186 of this proceeding, that set forth all of those judicial admissions and the positions that they took, that this was not Comair's property. And now, it's like that never occurred. We didn't say that, Your Honor, but they did say it. They said it in pleadings. We filed those pleadings with the trial court in this case, and it's part of this court's docket. And the spin that they continue to put on the fact that we wanted millions of dollars and we don't care about the damage it caused, we didn't get the millions of dollars, therefore we shouldn't be responsible for the damage that we have caused. It's not what contract law is about. When a contract is breached, the obligation of the trial court is to award the injured party the damages that were caused by that breach. Those damages include the cost of labor to move the parts. Not foreseeable. Marshal Lieberman was at the Trinity warehouse when he saw the trucks. He didn't see these parts float from the warehouse magically to the trucks. They were moved by laborers. What is unforeseeable about that event? They were under a time crunch because the landlord of that facility said, we can't do a sale on the site. You've got to move this stuff all out within days.
And can you go back? I'm still struggling with the notion that you're saying if there had not been a breach of contract, you wouldn't have charged them for these labor costs. But because there's a breach of contract, now you're trying to get that as damages. Because at the end of the day, you had to get the parts one way or the other to your place. And so if that wasn't part of the contract that they must pay for transportation costs, how is that an appropriate damage?
It's not part of the contract that they pay us for the labor incurred. The contract is, you sold us these parts, this property. And then we incur the cost to move those parts, move that inventory. And if they had said to the trial court, we sold it to A&A, we would not be here. We would not be here. And if we made money.
Right, but answer my question, like, how does the breach change the fact that you can now recover this damage, whereas if there had been no breach, you would not have been able to recover this damage?
In reliance upon the contract, and Judge Nestor awarded us reliance damages, we incurred labor expense to move the parts. When they took the parts away from us, did not deliver the parts to us, just like the trucks, just like the storage, those labor costs were costs that we incurred on reliance upon the contract. And when the contract was breached, they became part of our damages and recoverable as compensatory damages and reliance damages.
So all the parts have been moved, they're sitting at your place, and by virtue of the breach then allows you to recover those transportation costs?
Correct.
Okay, I understand.
Yeah, we cited a number of cases that support that proposition, and it's damages 101. When you incur an expense or reliance upon a contract that the other side does not perform, you're allowed to recover your reliance costs to compensate you for those damages.
Okay, I understand.
I want to make the record clear. I think Mr. Glausom has stated, A&A did not consent to the appointment of the receiver. Trinity Aviation consented to the appointment of the receiver. We were not a party to the case at that time. It took us months. In fact, Judge Martin required us to move to intervene several months later. And so when he said that A&A consented to the receiver, we did not consent. The foreseeability argument is we could not have foreseen that Northside Bank and Trust would say, oh, no, we didn't have a contract with you. Well, that's not our deal. Or that it had ignored the fact that it had repossessed the property. The trial court decision to have the receiver sell the parts was based upon its conclusion, it's in the same letter decision, that there was no contract, which this court reversed. If Judge Martin had found there was a contract, he would not have authorized the receiver to sell the parts, because he would have said those parts belong to A&A. I'm just going for notes.
You are at your time if you'd like to take 30 seconds to wrap up.
I'll just say, again, don't allow Northside Bank to continue to spin the facts, spin their own arguments. Look at what they said at the time, look at the events that occurred, and don't believe that these parts magically floated. We incurred the labor expense. They caused the issues that were now before the court, and request that you reverse or remand with instructions to award the $101,000 we have sought.
Thank you. And Mr. Galasso, you have 8 minutes.
Thank you, Your Honor. So this came up in 2020, and that is that this court found that both parties thought these parts were worth millions of dollars until they weren't. Okay, so everyone had been under the assumption that the parts had more value than they did, and then they ultimately yielded nothing and they had no value. But no one found that out until later. But we do have another contract, aside from what the emails constitute, that followed the email contract. And that's at TD 358, Joint Stipulation 55. And that's the letter that A&A prepared, that both parties signed. And it says, quote, "None of us could have foreseen the accounting, warehousing, and other logistical difficulties that ensued, and given that there is no telling when the receivership will end, A&A will store the parts free of charge." So that's how they took the parts, free of charge. They brought those in. They took them under their own risk. They, undisclosed to other parties, had a joint venture with these other parties that came into the case that was not known at the time. And now we have this huge bill for moving and storage costs that far exceeds any recovery that could be had here. But one of the things that I wanted to touch base on was, this came up in A&A's reply, and what Mr. Fecker just said was that this property was not part of the receivership estate because it was part of the contract. And that's just not true. And that is a position that he took, I believe, on page 8 of his reply brief, or page 3 or 4 of his reply brief. Article 9 works this way, just like a car. You repossess a piece of collateral. You don't own it at that point. You have to sell it and go through the sale process. In this case, that sale would involve providing a bill of sale under Article 9, a secured party bill of sale. That was the whole reason of getting this receiver in the first place. So what's being conflated is contract formation with the completion of the sale. So this court has determined that a contract exists, but it has not determined that a contract has been performed or that there's been a breach. That was what the trial was about. So that ship sailed. No one has appealed that the receiver sold these parts and they're gone. Had they not been owned by the receivership estate, then they would have never been sold. So it's simply not an issue. One of the things that we have asked over and over again is for someone to address the mitigation argument, that these parts could have been purchased for gross sale proceeds of approximately $155,000. So once these parts came in, these are public sales. Some of the public sales happened at A&A's storage facility. They were free just as the rest of the world. And
But you have the burden on mitigation, and if A&A believed they had a contractual right, as they did, to some parts, like why would they, I don't understand that argument. Why would they then be compelled to bid on it in connection with mitigation damages?
because they'd already lost that argument. They had
But they won it later on the contract formation.
They won it on contract formation, but they did not appeal or challenge the receiver's sale order. So they could have come in and purchased those parts at prices that would be far less than the weigh-in pay. But the reason that they didn't is because the parts they didn't have that value. And subsequently, people found that out after the fact. But it's never been addressed by the trial court that there's been any effort to mitigate. And so there's two pieces to the mitigation. One is the ability to just buy these things at a public sale, just like a foreclosure sale. But the second is the 10 months. I mean, had they not withheld the receiver from possession for that 10-month period of time, then they wouldn't have run up the additional 10 months that came in the second trial verdict. So I'm kind of at a loss to determine. The judgment entry itself, or the findings of fact, says, the conclusions of law says it's reliance damages. But if you look at A&A's brief, they focus on compensatory damages, and in fact, they make the argument that it's somehow analogous to the court awarding attorney fees for the enforcement of a settlement agreement. And I fail to follow that. The reasoning for the settlement agreement theory is that settlement agreements are favored in the law, and so that when enforcing one, you can award attorney fees. But the contract damages piece, whether it's reliance or whether it's compensatory or whatever name you ascribe to it, it still has to be the proximate cause and foreseeable. And once the receiver was appointed, it's not even disputable that Northside had no control over what would happen with these parts. So there had to have been a breach prior to that time, and then the question becomes, if there was a breach prior to the receiver being appointed, what is the foreseeable and proximate cause damages that can come from that, and how do we get to these extreme numbers that go out over a period of 3 years? So in my view, in summary, I think the primary issue in the case is that there's not any case anywhere, and we conducted extensive research, that essentially would find a breach of contract that exists because the court granted a receiver's order authorizing sale that a party supported. I mean, the court may have granted that had no one taken a position on it. There were certainly competing motions by multiple parties to that. That's what the sale order was. The sale's been completed, the receivership is over. The question becomes, are these damages the natural and proximate result of that? And they're just not foreseeable from the time of contract formation. So I have nothing further unless there's questions from the court.
Thank you.
Thank you, Judge.
Thank you both for your arguments. This case has been submitted, and we will issue a timely decision.
All rise. This first conversation of the House is now in recess. All rise. The Court of Appeals for the County District of Ohio is now in session with the Honorable Judge Pierre Ferdinand presiding.
Welcome back, everybody. Mr. Fecker, you're doing a double header today.
Yeah, Mr. Glass will pull a fast one. I thought he was also arguing 2 in a row, but he pulled in a switch hitter, so
How much time would you like for rebuttal?
I'd like to reserve 5 minutes for a rebuttal.
You may proceed when you're ready.
Good morning, Your Honors, Counsel. I represent the appellant in this matter, Mr. Angelo Slabakis. The entry granting plaintiff's motion to vacate the satisfaction judgment needs to be reversed because the trial court abused its discretion in granting plaintiff's motion to vacate that entry of satisfaction. The trial court granted plaintiff its requested relief and ignored the prejudice that Mr. Slabakis would suffer if the entry of satisfaction was vacated. Completely mischaracterized the events and pleadings which caused plaintiff to request the vacation of the entry of satisfaction from the court, prevented the New York court from deciding the actual disputed issues regarding the release, ignored Ohio's strong preference for the finality of judgments, and permitted plaintiff to sleep on its rights for years without consequence. Although on this last point, to be clear, any attempt by plaintiff to vacate the entry of satisfaction after my client's appeal had been dismissed as agreed would have caused Mr. Slabakis to be prejudiced. As we argued in our brief, when a party dismisses in a pending appeal, that appeal is with prejudice. So the issues that Mr. Slabakis sought to have reviewed by this court, in which he agreed in the agreement with Platinum Real Estate to not pursue, were waived upon the filing of the dismissing his appeal as required by the agreement that the parties reached.
Counsel, what is the technical impact of the trial court's 60B order? So it vacated the satisfaction. Does that mean that the underlying judgment is now resurrected?
It means that, yes, it does. It also means, because of the interest rate that the original judgment has, I did a calculation, that judgment went from $3.6 million to well over $5 million.
And just to understand, following up on Judge Kinsley's question, you're saying it resurrects that because now that you don't have proof of satisfaction, they could just go enforce because you haven't satisfied the judgment.
Correct. And in fact, it's not part of the docket because the appeal was filed. They have filed motions for discovery to obtain asset information regarding my client. They filed a motion for contempt against my client for not providing that information. And they're using that judgment amount, they plan to use that judgment amount as a set-off against this New York litigation.
So in that regard, counsel, isn't this 60B order really tantamount to a finding of breach of contract?
It is, but it's an incorrect finding.
Well, was the question of breach of contract even litigated as part of the 60B?
So I will get around the ancient question, but I have to give the background. So there was a guarantee that Mr. Slabakis had signed, and that was the basis for the cognitive judgment that entered that resulted in the judgment. Mr. Slabakis took a position that he had entered into a contract or assisted other parties to obtain a sale of the Terrace Hotel, and that he was entitled to a fee for the work that he performed. That's the basis of his New York action. So when Judge Wagner says that Mr. Slabakis wanted to relitigate the issues, that is a complete misreading of what had occurred.
Well, counsel, let me make sure I understand. So I think your opponent's position is that the mere filing of the New York action constituted a breach of the settlement agreement that resulted from the first appeal. And isn't the 60B in essence tantamount to a finding that Mr. Slabakis breached that settlement agreement?
Again, it is, Your Honor, but when you take a look at the New York pleadings, which were attached to the motion to vacate, it is not a breach. It is a complete misreading of the New York action. And
I mean, I haven't paid attention too much to like exactly what was happening in New York, but presumably, if someone files an action in New York that's covered by a settlement agreement, isn't that the defense? You come in and be like, this is covered by a settlement agreement, dismiss the case.
And that's exactly what occurred, Your Honor. So when Mr. Slabakis filed the suit in New York against entities that are not parties to the release, those defendants filed a motion to dismiss saying we have a release. And the trial court, and I don't know what the New York trial court is called, it's different than ours, agreed and dismissed it. The Court of Appeals then reversed, saying that I don't believe anybody has addressed the fact that there's two different parties involved or the party's not unanimous, but says under New York law, this release may not cover these facts. And it was months after the Supreme Court, or the appellate division, first appellate division in New York, reversed the trial court, that they came back to Ohio, and they repudiated the settlement agreement, mutual release, and filed a motion to vacate that entry of satisfaction.
So, counsel, what I'm hearing is a dispute as to whether or not the filing of the New York action constituted a breach of the settlement agreement here. And if that's the case, is 60B even the appropriate vehicle, or should this have been a breach of contract action?
It could have been a breach of contract action. It could have been, as Judge Barron indicated, a motion to dismiss in the New York action. It could have been a number of different things, but it could not have been and should not have been a motion to vacate the entry of satisfaction because they waited too long and that we were prejudiced by that delay.
And here's another question I have too. Is 60B even the appropriate vehicle for vacating a satisfaction of judgment as opposed to a judgment itself?
There are cases that permit a entry of satisfaction to be vacated pursuant to a 60B motion. In those cases, we cited them to the trial court, it did not come up on appeal, or when the satisfaction of judgment is as to the wrong party. We cited a case, I believe, out of the first district where the plaintiff had reached an agreement with defendant A to satisfy a judgment, filed it as to defendant B, and then when they sought to enforce it against defendant B says, no, the judgment's been vacated, and they filed a motion under clerical error or mutual mistake. So 60B can be a vehicle to vacate an entry of satisfaction when it's improperly done, there's a mistake in the process. There are cases, and if you want, I can provide that authority to you, to the court, but we cited it to the trial court, and the trial court agreed with our analysis because when they filed their motion, Platinum Real Estate said that the court has the inherent authority to vacate.
Right, they weren't moving under 60B, right? Were they?
I believe that they did both. I know the court, I raised the issue under that they had to proceed under Rule 60B, and I believe the trial court agreed, and said we're going to decide this under 60B, because one of the issues was only one of the rules, and I forget one, you have to file within a year, and Mr. Galasso argued an oral argument that we're not proceeding under that section of Rule 60B, so therefore we're not bound by the one-year limitation, which the trial court agreed with, ignoring the fact that every 60B has to be filed within a reasonable period of time, and our argument that waiting almost 5 years to file the motion was an unreasonable period of time. And again, as I said earlier, once we dismissed our appeal, they were barred from ever vacating that satisfaction. So perhaps a breach of contract action would have been the appropriate methodology to pursue that claim. But that's not what they did, it's not what the trial court ruled upon. Did I answer your question?
You did, thank you.
Okay, thank you. Getting back, it is an abuse of discretion standard. This court has stated a decision is unreasonable when it's not supported by a sound reasoning process. In the Cincinnati Bell versus Midwest Music case in 2006, and in 2023, the 12th District Court of Appeals, each the same decision in Potter versus Butler County. We believe that the trial court was unreasonable. It ignored the issue of timeliness, and it simply did not account for the prejudice to Mr. Slabakis. When you read the entry, that issue is never discussed by the trial court. And again, as Judge Barron indicated, it took the decision away from the New York Court of Appeals or the New York trial courts as to whether or not that mutual release was impact and cause a dismissal of that action. And there was no need to do that because, as we stated in our brief, we stated along, if the New York court said that release encompasses that litigation ends. If the New York court says that release does not encompass the litigation, it doesn't end. In conclusion, Mr. Slabakis did not repudiate the agreement, but Platinum did. Mr. Slabakis has been severely prejudiced. I see that I'm out of time. Unless the courts have any questions, I'll wait for my rebuttal.
Thank you.
Thank you.
Mr. Rust. Morning.
Morning, Your Honors. May it please the Court, Charles Rust for Platinum Real Estate Holdings Incorporated. The question before this Court today is, was it an abuse of discretion for the trial court to vacate the satisfaction of judgment under Rule 60B-4? As counsel has agreed, it is an abuse of discretion standard. So what that means is it's only, the decision can only be overturned if no reasonable person could have agreed with the trial judge in making that decision. There are three elements under the GTE test for.
Right, but just help me understand, like, there's this litigation going on in New York, and New York says, ultimately, I guess, this claim can move forward. So how is that a basis to justify 5 years after the fact a 60B vacating of the judgment?
Sure, Your Honor. There are a lot of layers here. The New York case, I think initially there was a thought that it could be resolved by dismissing it. And on the initial go of it, Mr. Slobakis characterized his claim as it wasn't a syndication, but it was a commission from the sale. But he's a 20% owner in the purchaser of the property. Under Ohio law, he wasn't entitled to a commission. So he went up on appeal in New York, came back. The New York court said, well, you can't let him recast his claim as a syndication claim, and at the same time said there's also this issue with this mutual release in Ohio, so we're going to let this thing go forward. And so it was at that point, as the parties got into the midst of the litigation there and said, hey, this looks like it's not going to resolve. He has a claim against us for $1.5 million. We have this judgment in Ohio that's arguably more than that now, and we think we should be able to offset.
And forgive me if I'm jumbling the procedural history, but
Sure.
You had filed a satisfaction of judgment here, which, as I understand it, means you got paid for whatever the judgment was, or you reached some accommodation and entered that satisfaction of judgment. So if you are now trying to blow up the satisfaction of judgment, are you giving them back consideration that was paid?
So the consideration for the satisfaction of judgment here was this idea, hey, we're trying to sell this property. We also have a claim against you. If you help us sell this property, we'll release our claim against you. And then as you see in the record, there's the mutual release. And it's, the New York case, if you look at the pleadings, it's trial docket 29, Exhibit C, his verified complaint in New York. There are a few things worthy of note there. One is they try to characterize it as sort of a three-pronged settlement agreement. Not only did it include the sale in Ohio and the release here, but it also included other stuff on top of it.
Well, counsel, to that point, the New York court is fully capable of reviewing the settlement documents and everything that was filed in Ohio without a 60B being granted, right? None of these things are sealed or anything like that, right?
That's correct, Your Honor.
And then a question as to the application of 60B. So at what point, in your perspective, did the prospective application of the satisfaction become inequitable?
Sure. In our estimation, it became inequitable as soon as the New York case was filed. But I think there was some practical utility to try to resolve that without having to come back.
But then, so you waited from that moment until the New York appellate court reversed before you filed the motion, right?
Correct, Your Honor.
Okay.
Yeah, as soon as it was apparent that matter was going forward and there was no hope of resolving it, it seemed prudent to come back here and revive things here.
Let me ask you this, Mr. Rust. It's been my experience that once a judgment is satisfied, the person satisfied, you take an entry of satisfaction to the clerk, and the judge has no involvement with that satisfaction. Now, I know in this case you've had a motion for satisfaction, and the judge signed that without the participation of Mr. Fecker, or with the agreement of Mr. Fecker because of satisfaction. So this is my question. Is that a judicial act or is it simply a ministerial act where you don't need a judge's signature to file an entry of satisfaction, yet you go ask the judge via motion for, is that a judicial act?
I believe it is a judicial act because there was a motion filed. And I think the rationale at the time was, this is an atypical satisfaction of judgment. I mean, it involves a settlement agreement between the parties. It's not like money.
Was that attached to the satisfaction of judgment, the agreement or the settlement agreement?
So the settlement agreement is in the record now. I don't know right.
Well, that was when you came back and filed your motion to be relieved from the entry of satisfaction. I don't know, it doesn't make sense. To remove the entry of satisfaction, that's when the court first became aware of the, at least my understanding, of the settlement agreement. Is that correct?
I believe at the time of the satisfaction of judgment, I believe the court was aware of the fact that it was a settlement.
Was it filed with the court?
I don't believe it was, Your Honor.
Okay.
But there is a case we cited in our brief. It's Ellen v. Corp. v. Edgar. It's out of the 12th District, 2012, Ohio, 1899. It deals with the application of Rule 60b-4 in this context, where there was a satisfaction of judgment or breach of a settlement agreement, rather, and the case was resolved essentially by agreement like this one, and then the court came back later under 60b-4 and said, hey, you guys, because there wasn't an agreement, it was appropriate to revive the case. And that's really what we're...
Counsel, isn't this really a breach of contract action? I mean, you're saying filing the New York action did breach the settlement agreement. They're saying, no, it didn't. So why is this not more appropriate for a breach of contract action where this dispute of fact and perspectives can be duked out rather than a 60B?
That's a great question, Your Honor. I think it is one appropriate way to do it. I think it might be helpful to characterize this as an election of remedies. I think in this case, I mean, this is, the judgment that we're talking about here is from a case that was filed, I think, the first case was a 2014 case where the property was actually sold. So there's a lot of layers, a lot of history. If you look to, just to address some of those layers here, the verified complaint filed in New York at least twice, I know in paragraph 14 and paragraph 17, Royce Poyagis is one of the defendants in the New York case. And in the filing of the action against him is essentially what we're saying is the breach of the settlement agreement. And in those paragraphs, in his verified complaint, Mr. Slabakis treats Platinum and Mr. Poyagis as one and the same. He said he's saying that his deal in this instant case here in Ohio was with Mr. Poyagis, even though it was with Platinum. So under the purview
Right,
of
so to that point, Platinum's not even a party to the New York action, right?
Correct. And so the link between Platinum and this, there's a...
I understand everything you're saying, but these just seem to be arguments that should be directed at the New York court to try to resolve that case rather than to us to unravel a case that had been decided a long time ago here.
Understood, Your Honor. And all we're doing, really, if you boil it down, is we're giving the New York court all the tools to make its decision. Because we agree, ultimately...
I presume it's pretty capable of making its own decisions.
Well, our concern is that the New York court doesn't have the power to reactivate this judgment here in Ohio. What it does have the power to do is to decide whether...
No, because, that was decided over multiple years ago.
Right. And so what they do have the power to decide, though, is can that judgment be used as set-off and recoupment in that New York court? If it's inactive, they can't use it for anything.
But I guess, I'm still having trouble with the 60B application under these circumstances. And, Mr. Fechter makes the point about how they dismissed their appeal in reliance on the settlement agreement, and they don't get that back, right? There's no mechanism to give them that appeal back. So isn't that prejudicial to them?
I would agree that it's prejudicial, but I would disagree that there's a place for that under the 60B analysis. I think the case law is pretty clear that the only place prejudice applies is with regard to timeliness. And the way that works is was there a change in status quo based on the delay? And I don't think there was. Even if we filed the motion to vacate the day after they filed the New York case, Mr. Slobakis's rights would have been the same at that point. Even if we had filed it before that, just for the sake of argument, nothing would have changed. So there's no material difference in the rights that Mr. Slobakis has here in Ohio based on the timing of when this motion was filed. And that's the only lens through which prejudice can be examined.
Counsel, let me just kind of walk through, and I mean, this is a complicated case, and I may be oversimplifying the facts, but as I understand the nature of this judgment, it's a deficiency, right? There was an amount that was owed. Mr. Slobakis was the personal guarantor. Building got sold. There was some amount of money that was still due. Platinum came after him for that amount of money. He may dispute, I don't know, but he may say, no, that, the building could have been sold for more, you undersold it. He may have a range of defenses related to that judgment against him personally. I have no idea if those would be valid or not. But he didn't assert those, and he didn't raise those in an appeal because you all reached a settlement. And now I understand your perspective is, well, he breached that settlement by filing this New York action. Couldn't all of this be best sorted out in a breach of contract action where the damages could be looked at, the valuation of the property could be looked at? Why is 60B the right vehicle for these issues?
I think just given the unique nature of this case, we felt that 60B was appropriate because it addresses the fact that there are multiple cases here. And really the underlying consideration, as the trial court found, for this agreement was the dismissal or the release of claims. And when that release was violated, it seemed like, what's the piece of consideration for that deal? It's this satisfaction of judgment. No money ever changed hands. It just said, hey, if everybody performs under this deal, we're going to release you. And it's pretty, and I think, with regard to breach of contract, if we're under that lens, the law in Ohio on that says if a party breaches, then the non-breaching party has no further obligation to perform. So it's kind of under that same theory, but it's a different vehicle to get there.
And can you help us assess why the 60B motion was not filed in 2018 when the New York suit was initiated? What's the reason for the delay?
The reason for the delay, essentially, Your Honor, was to see whether the matter could be resolved without getting into a judicial battle here in Ohio. If the client could save resources without opening a case here, incurring costs, incurring the expense of doing it here, they thought that was prudent.
All right, so it's self-help, being efficient.
Sure.
Okay, and looking at the timeline, so 2018, the New York suit gets filed, there's litigation going on in New York. 2021, the New York Court of Appeals reaches its decision and kicks back a piece of the case for the trial. Why not then file? There's still about an 18-month delay before the filing.
Yes, Your Honor. I think that delay can be attributed to developing litigation strategy. So they find out at that time that the case is going forward, and they say, okay, well, what are our claims here? What are our defenses? How do we work our case? And I think through part of that development, the decision was made to come back here in Ohio. Hey, maybe this judgment has some application here in New York. The problem is it's a satisfied judgment. We can't really assert a satisfied judgment as a set-off in New York. But if that satisfaction were somehow lifted, then we could do that. And everything's squarely in New York. The New York court can say, well, the New York court has the power to say, I don't think that applies to this case, or it does. But if the satisfaction is never vacated, they never get to make that decision. And I think that was the impetus for us doing this in this case, rather than a separate breach of settlement agreement action or anything like that.
And you are at your time.
Thank you, Your Honor.
Thank you. Mr. Fecker, you have 5 minutes.
I may jump around a little bit to address some of the questions that the panel has raised. Mr. Counsel argued that the reason they wanted to vacate this satisfaction is because they want to give the New York courts all the power. That's false. As Judge Bearjohn indicated, that the New York court determines the release applies, the New York case is over. What they wanted to do is create an amount owed by Mr. Slovakis that they could use as a set-off against any liability in New York. That's not giving the New York courts the power. That's repudiating the purpose of the settlement agreement. To answer Judge Winkler's question, in 2018, when the motion to satisfy the judgment was filed, the release was not attached. The motion to satisfy the judgment or enter the satisfaction did not reference a settlement. It simply said the judgment and costs have been satisfied. So on top of everything else, we're allowing counsel to recharacterize what they filed in 2018 to create these issues. That goes to
Counsel, am I correctly understanding that the impact of the trial court's 60B is to essentially say that your client now owes millions of dollars that he previously did not owe? And that is because he filed a lawsuit in New York?
Correct. And to answer your question that you raised earlier about what arguments we have significant arguments as to how the amount of the judgment was arrived at. In their brief, they said that amount is set forth in judgment entry and journal entries. It is not. There is no judgment entry or journal entry that matches up with the amount of money they've claimed, which is the issue that we wanted to raise on appeal, which we waived. And so that gets to Judge Bergeron's question about if you want to revoke this mutual release, don't you have to give them back to consideration? In essence, they're arguing the court should rescind the release. And this court is well aware when you rescind a contract or rescind something, the parties you have to return the consideration. They can't return the consideration that we gave up. What we gave up was the right to pursue an appeal of the amounts owed. So the argument that they are, this is just to create give the New York courts power, ignores that issue. It's clearly forum shopping. They were unsatisfied with the New York decision to reinstate the New York case and leave open the question whether or not the release, covered that litigation, and to claim that we waited all this time since we were developing a litigation strategy. I've read the civil rules, and I don't see an exception in timing requirements for you get more time while you're developing litigation strategy. You have to act within a reasonable period of time. Yes,
Was
Your
there
Honor.
any filing in the New York litigation by Platinum or the affiliates of Platinum that would have suggested that set-off was an issue prior to 2023?
I'm not too sure because they did not attach a copy of their answer to the New York complaint at any point in time. I'm relying upon their representation that they intended to do so, and that's why they filed the motion to vacate. But I don't have an answer to that question, Your Honor.
From your perspective, when would it have been reasonable for the Platinum affiliates to identify set-off as an issue in the New York litigation?
I think they could have raised it once the answer was filed. I think that would be appropriate time since they lost the motion to dismiss. Again, Your Honor, we believe the trial court abused its discretion for the reasons we've argued both today and in our brief, and request that you reverse that decision.
Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision and hope you both have a great day. Thank you.
All rise.